Hello everyone. We are going to do the third video study session on industrial law, and today's lesson is on mechanisms for settlement of industrial disputes. So before starting the lesson, I would like to suggest that you have the note you're provided with through the exam help group with you while listening to the lesson. Because as I'm going through the lesson, there will be I will be referencing to quite a few number of sections in the Industrial Disputes Act. So it will be hard for you to keep track of all the numbers and the particular content if you don't have the note or at least the Industrial Dispute Act itself to refer as we go through the video. Okay, so let's start the lesson. Now, yes, before going into the mechanisms available for the settlement of industrial disputes, let's discuss what is an industrial dispute actually is. So, as the word dispute suggests, it is a difference or a conflict that arises between parties involved in industries, as in the general the employers and employees. So this sort of disputes or differences, conflicts may be arising between employers and employees, sorry, as in I mean since there are both employers and employees in industries, these differences or conflicts may be arising between employers and employees, or it could be arising between employees and employees, or they could be arising between employers and employers. Now, or what could be these parties having conflicts? So it could be about the working conditions of the employees, or the termination of their services, or it could be about someone's services being terminated. So basically, an industrial dispute is a difference or a conflict arising between parties, like employers and employees involved in an industry over conditions of work, conditions of employment, termination of services, and reinstatement of services. So you can find the definition, the industrial dispute have been defined in section 48 of the Industrial Disputes Act. So refer to that also. So what are the mechanisms available to settle such industrial disputes? Now you can see these the methods the mechanisms we are going to discuss here referred in the Industrial Disputes Act. There's four main mechanisms you can mainly three, but let's add the adjudication also, it is a mechanism for settlement of industrial disputes, but we will not be discussing about that part in this lesson. So the mechanisms referred to in the act are collective agreements, conciliation, arbitration, and adjudication. So but how can what is a settlement of industrial disputes by collective agreements? So what is a collective agreement? You can find the definition for collective agreements in section 5 subsection 1 of Industrial Disputes Act. So it is basically an agreement. It is basically an agreement between employer or employers and any workman or trade union comprising of workmen. Okay, so these sort of agreements could be on matters such as like terms and conditions of employment, privileges, rights and duties of employers, workmen and trade unions. Okay, so what is a collective agreement? It is basically an agreement between employers and employees regarding matters such as terms and conditions of employment, rights, privileges and duties of employers, employees and also trade unions, which are comprised of workmen. Okay, so now that we know what is a collective agreement, now what happens when an industrial dispute is referred to be settled by collective agreements is like the parties involved in the dispute will enter into discussions and come to a middle ground where the terms and conditions are agreeable to the both parties. Yes, and once that happens, once they are able to agree upon terms and conditions that are fair to both the parties, uh, they will note down these terms and conditions in a document and sign the document, and this will be the collective agreement. Okay, so the next mechanism is conciliation. So unlike in the collective agreements, when an industrial dispute is referred to be settled through conciliation, there's going to be an unbiased neutral party, third party involved. So you can call this person the mediator or the authorized officer to lead the conciliation. This mediator could be the labor commissioner himself or some other authorized officer appointed by the labor commissioner. Okay, so what this mediator does is like he will try to induce both parties into like coming into an agreement that is both fair and amicable to the like to both parties. Like he will do so by like discussing separately and together, separately with the parties and also together with the parties, and try to understand their differences and come up with solutions to it. Like try to induce the uh, involved parties into finding a middle ground where both the parties can agree upon. Yes. Now, arbitration is like similar to what happens in conciliation also, but it differs. Like as like it is similar to conciliation because there's also an unbiased neutral third party involved in the mechanism, but it is different from conciliation because the decision of an arbitrator, we call this an award of an arbitrator is binding upon both parties. He will discuss with the parties, hear all evidences, conclude all the necessary investigations, come to a decision, and he will declare it, and that will be binding upon both parties. And adjudication is basically like when the dispute is taken up to the labor tribunals or industrial courts. Okay, so now let's talk about the powers and functions of the labor commissioner. Okay, so let's say I'm the labor commissioner. Okay, and I get a report from someone saying that there's a dispute going on in this particular company. And once I look into it, and if I am satisfied there indeed is an industrial dispute happening going on in that particular company, it is up to me. It is the function of the labor commissioner to make inquiries into the dispute, take necessary steps to satisfy the to settle the industrial dispute by means referred to in the act or otherwise. So by means referred to in the act, these means are conciliation, collective agreement, conciliation, and arbitration. Okay, so but like if you listen closely before, like I said the word otherwise. uh, the word otherwise is mentioned in this section 2 subsection 1. So this word otherwise has bestowed upon the commissioner a considerable amount of discretion. Like he is free to seek a method to settle the dispute he sees is fit, if other mechanisms referred to in the act has failed to settle the dispute. Okay, so yes, that is the function of an of a labor commissioner, and the powers of labor commissioner is stated out in the section 3 of the Industrial Disputes Act. So it is the power, it is within the powers of the labor commissioner to refer industrial disputes to be settled by collective agreements, conciliation. He can act as the mediator himself, or he can authorize someone else to do so. Like he can authorize appoint another authorized officer to act as the mediator, or he can refer the dispute to be settled through arbitration if only the parties involved gives their consent to it. Yes, we call this like voluntary arbitration. Okay, so now that we know what are the powers and functions of the labor commissioner, let's see what happens when he refers an industrial dispute to be settled through a particular mechanism, and through a particular mechanism, and it does settle, and what the labor commissioner has to do from that point onwards. Yes, so I'm going to be discussing the content in sections 6, 7, 8, and 9 next. So please read through those sections. Okay, now we know what is a collective agreement is. Let's say okay, let's take an example because that would be much easier. Let's say a company, like there's a textile factory, and the trade union there has started a strike action against the employers, demanding better working conditions, like improved wages, or like improved restrooms, stuff like that. So the commissioner has referred it to be settled through collective agreements, and after discussions, both parties have come to an agreement, and they have sorted the terms and conditions of that agreement. So once that happens, these terms and conditions of this agreement is written down and signed by both parties. Once this is done, this will be transmitted to the labor commissioner, and the labor commissioner will publish this in the gazette. There's a proviso to this. He will, like, if the collective agreement is about conditions of employment. Now I said in the example that this trade union was striking, demanding better working conditions. So that means this is something about conditions of employment. So if in this particular collective agreement, the terms and conditions they have come to agreed upon is unfavorable to the employees when compared with similar collective agreements in the industry. Now, the particular collective agreement I'm talking about happened in factory A, and there's a similar factory called B, and the terms and conditions they have come to agree upon in this collective agreement is unfavorable to the employees when compared with this company's collective agreement. Okay, if that's the case, the labor commissioner will not publish that collective agreement in the gazette, and a collective agreement is only applicable after it is published in the gazette. So from like, what is the date, like from which day onwards shall this collective agreement come into force? Now it could be either on the day that is published in the gazette, like the day on which the collective agreement was published in the gazette, or the specific date that has been stipulated in the agreement itself. So let's say in this agreement, it has been sent to the labor commission, and he decides that it is not unfavorable to the employees, and he decides to publish it in the gazette, and he does so on 15th of September. Yes, but there's a term in this agreement stating that this agreement will come into force on 30th of October. Yes, then that particular agreement will come into force on 30th of October, despite being published in the Gazette on 15th of September. All right. So, yes. Now, for how long will these collective agreements be effective? Now, collective agreements are effective for any time period, or for the time period that is stipulated in the collective agreement. Now, like if the collective agreement contains a term stating that this agreement will cease to be effective on this date, or after 6 months, once the time period expires, the contract also ceases to have effect. Yes, that is unless, of course, one of the parties to the collective agreement decides to terminate the agreement. Now, how are they going to terminate an agreement? Terminate a collective agreement. Yes. Yes. What to do when you're, like, let's say you're the secretary of the trade union that has come to the has a, like you're the secretary of the trade union that is part of this collective agreement, and after some time, before the expiry, like before the date, like yes like yes no like let's say you're the secretary and you want to like the trade union wants to terminate the contract agreement. So what you have to do is you have to write a notice of repudiation to the commissioner and the other party. Yes, and once you do that, the commissioner will terminate, like the the agreement will be terminated after, after 1 month after the expiry of the month in which the commissioner receives the notice of repudiation. So that may be a bit confusing. So let's say I'm the labor commissioner. I receive your notice of repudiation on 15th of September, and the agreement will be terminated only on only in November. That is November 1st. Yes, that means like I received the notice in September 30 or 31st. I don't remember the number of days. Like at the end of September, that means expiry of the month in which I have received the notice of repudiation, and after 1 month, that is October. Yes, after 1 month is October. Expiry of the month in which I received the notice of repudiation is September. Yes, okay, so I hope that you got right. And of course, if this notice of repudiation is sent by a member of the trade union, independently of the trade union, like let's say now you're the member of a trade union, like the trade union has no has no, like they do not, like the trade union as a whole do not wish to terminate the agreement, they're happy with it, but you individually want to terminate the agreement, and you write a notice of repudiation to the commissioner and the other party. This is not applicable. This notice of repudiation will not be accepted. And it is important to note that terms and conditions of these collective agreements are considered to be implied terms and conditions of conditions in contracts of employment. Okay, so let's move on to settlement of industrial disputes through conciliation. Okay, so please read through the sections 11, 12, 13, 14 and 15. Like stuff I'm going to talk about from here onwards is mentioned in those sections. Okay. Yes. All right. Conciliation. Conciliation as a mechanism to settle industrial disputes. Now, when an industrial dispute is referred to be settled through conciliation, it is of course the duty of the mediator to induce both parties into entering into an amicable and fair agreement. I've said that before also. And like the investigations into the dispute, like once like I'm the mediator and I'm investigating into the dispute at hand, I have to conclude this in all these investigations within 1 month. Okay. And once I succeed at inducing getting both parties to come to a middle ground, I will be drawing up a memorandum, okay, containing all the terms and conditions of the agreement. And this memorandum will be published in the Gazette by the Labour Commissioner if it relates to a major industrial dispute. Okay. And so, like, these are similar stuff, like you only need to know these things both in collective agreement and conciliation. So when is it coming into force? Like when is this conciliation, like the terms and conditions agreed in the memorandum coming into force? It will come into force on the day the memorandum is signed. Okay. Or it could come into force on the day it is published in the Gazette. Okay, if it's related to a major dispute. Or from the day from the day onwards, from like stipulated in the agreement. Yes. And same as in the collective agreements, terms and conditions of the memorandum are considered to be implied terms and conditions in the contracts of employment. Okay. And yes. And then again, let's say one of the parties wish to repudiate the terms and conditions they have agreed upon in the conciliation process. I'm sorry. So similar to the process in collective agreements, the party who wishes to terminate the agreement has to write up a notice of repudiation and send it to the Labour Commissioner and the other party, and the agreement will be terminated 1 month after the expiry of the month in which the notice is received by the Labour Commission. Same as before. Okay, same as in the collective agreements. Yes. Now again, similar to the collective agreements, if the notice is written by someone who is a part of the trade union that is that has signed in the contract in the agreement, but he writes this notice of repudiation independently of the trade union, then in that case that notice of repudiation is not applicable. Yes. Okay. And in the section 40 of the Industrial Disputes Act, it says that no workman or trade union can strike against a settlement, and it shall be shall be an offence under the Industrial Disputes Act. So we'll discuss about arbitration and adjudication extensively over the next few lessons. But let's quickly discuss about the powers and functions of the minister. So, according to Section 4, subsection 1 of the Industrial Disputes Act, the minister can refer minor disputes for compulsory arbitration. This means that the minister can refer these disputes to be settled through arbitration, whether or not he receives the consent of the parties. Yes. And section 4 subsection 2 of the Industrial Dispute Act says the minister can refer an industrial dispute to an industrial court to be settled, and industrial courts also will be discussed in the next lesson, over the next lessons. So that's all I have set out to do in this video study session. I hope you understood everything. This area also has been tested in the exams. Like there's questions like write a note on powers and functions of the Labour Commissioner in relation to the Industrial Disputes Act. So all you have to write down is like basically the sections I just talked about. Okay. So yeah, have a good day.